Thank you all for coming today. I'm going to briefly address why we're addressing this issue. Secondly, what our constitutional amendment states, what it will do, and then fourthly, the process by which we intend to have this proceed due to the Attorney General and ballot board or otherwise through the courts. First of all, a few quick notes on why the 1851 Center for Constitutional Law cares about this issue. And my name is Maurice Thompson. I am the Executive Director of the 1851 Center for Constitutional Law. We are representing the Ohio Liberty Counsel pro bono in their efforts to collect these signatures and also in any kind of litigation that may ensue pursuant to this amendment. We're doing that because we do believe that there is an element of tyranny here, and I'll be happy to answer that question that was interposed to Chris Littleton just moments ago. Chapter 48 of the Senate bill, which was adopted by the House just last night, requires nearly every American to purchase what's characterized as minimum essential coverage, as defined by the federal government, and makes it a crime, in fact, a felony, when read in conjunction with IRS laws, to fail to do so. What we know about healthcare mandates from Massachusetts is that the cost of healthcare in Massachusetts skyrocketed. Premiums increased by 12% per year since 2006, and overall cost of insurance is up 25% in Massachusetts since 2006. This plan is in fact one very similar to the Massachusetts plan. Meanwhile, when you have a mandate, you have a lobbyist feeding frenzy. Every insurance industry lobbyist under the sun is going to be down in DC lobbying for their particular product that they offer to be covered under the mandate. That drives up the cost of insurance and forces us all to purchase things that we do not want and do not in fact need. That makes insurance more expensive, not only for the individual, but for society as a whole. Thirdly, the mandate actually forces Americans to buy a commercial product, whether or not it's in their best interest to do so. For some people, it's perfectly efficient to self-insure. For some people, maybe that's not the right answer, but we do believe in freedom of choice as well. And fourthly, the mandate, most importantly, is tyrannical because it attempts to transform our federal government from one of limited powers to one of unlimited powers. And the reason this is true is because the mandate's authenticity is offered under the Commerce Clause. That is the guise by which it is advanced to be a legitimate function of government. The Commerce Clause states that the federal government can regulate commerce amongst the several states. Commerce is economic activity. If commerce is in fact found to be inactivity, the failure to purchase any product, well, then it's similarly true that commerce could be your failure to go to the gym, your failure to go to a health club 5 to 6 to 7 times per week, your failure to eat red meat, or your failure to be a vegetarian. And that sounds a little bit ridiculous, but maybe 50 years ago it sounded a little bit ridiculous that the federal government would force all of us to purchase not just health insurance, but the particular type of health insurance that they in fact mandate. Secondly, I don't know if you all have a copy of it. This is our initiative petition. This is in fact the constitutional amendment that we will be filing just an hour from now. As Chris indicated, about 3,000 signatures were gathered. The amendment is entitled to preserve the freedom of Ohioans to choose their health care and health care coverage. What it does is it adds Section 21 to the Ohio Constitution, Article 1. Article 1 is the Ohio Constitution's Bill of Rights. There are currently 20 sections. So if our amendment is successful, there will be 21 sections to Ohio's Bill of Rights. The 21st, providing the text that is in this initiative amendment. Basically, in Ohio, no law or rule shall compel, directly or indirectly, any person, employer, or healthcare provider to participate in any healthcare system. What this does, it does a few other things too. No law or rule shall prohibit the purchase or sale of healthcare or health insurance in Ohio. And thirdly, no law or rule shall impose a penalty or fine the sale or purchase of healthcare or health insurance. What this language does is gives Ohioans the right to choose whether to participate in any kind of healthcare system, be it public or be it private. What it does not do is affect any law that was in effect as of last Friday. What it does not do is affect Medicare, Medicaid, in any way. What it does not do is affect any criminal law or criminal sanction that may inure to a dishonest or fraudulent healthcare provider or any other member of the healthcare industry. It also does not affect mandates on hospitals to provide coverage, and does not affect terms or conditions of government employment. Now for the difficult part, how this works legally. And this is somewhat esoteric. It's hard to have a soundbite takeaway, which I would love to provide you with, but it's quite simply not that easy. As most of you know, most of the time when a state law and a federal law conflict, the federal law takes precedence. It's called the Supremacy Clause of the United States Constitution. So we all use that as a rule of thumb, including myself. However, this is something that's true most of the time. It's not something that's true all the time. The reasons for this are myriad, and the ways in which it's not true all the time are also myriad. However, suffice to say, to trump the constitutional amendment that we've offered here, the federal government will have to demonstrate that the Commerce Clause that I talked about earlier does in fact give it the authority to mandate the purchase of health insurance. For reasons I articulated a little bit earlier, it is a standard that we don't expect the federal government to be able to meet, because the mere inactivity of existing as a human being is not commerce, because it's not economic activity. What this means is that the federal government falls back to the necessary and proper clause. In other words, there are the delegated powers under the federal Constitution in Article 1, Section 8. One of those is the power to regulate commerce amongst the several states. And then after all the delegated powers, there's something called the necessary and proper clause, which allows Congress to make laws and rules necessary and proper to the effectuation of those delegated powers. However, because the healthcare mandate we discussed earlier is not strictly in compliance with the Commerce Clause, the federal government necessarily has to rely upon the necessary and proper clause to support the legislation. However, the United States Supreme Court is fairly clear that when legislation commandeers state sovereignty, it is in fact not proper. What this means is that the federal government will have to demonstrate not only that the legislation passed last evening withstands Commerce Clause scrutiny, but also is a proper exercise of their necessary and proper clause authority, something that's going to be very difficult to do. And it's important to understand the reason that we're doing this constitutional amendment is because this constitutional amendment actually enters into the calculus of whether or not something is proper under the necessary and proper clause. In other words, if we have a constitutional amendment in Ohio that protects the freedom of Ohioans to choose their own health care, the court has to take that into account as a state interest, along with the recognition that traditionally health care is an issue that's been regulated by the states rather than the federal government when determining whether or not the Commerce Clause and necessary and proper clause authority has been properly exercised by the federal government.